Good afternoon and welcome to today's presentation, Mold Litigation Defense, an Expert Witness View. In today's webinar, Dr. Rosenthal will discuss mold and its effect on health, medical causation analysis of mold illness, claims as a consequence of mold exposure, and differential diagnosis versus causal assessment. To give you a little background about our presenter, Dr. Richard Rosenthal, he is a board-certified internist in allergy and clinical immunology. He served 2 years at the National Institute of Health and the National Cancer Institute. Dr. Rosenthal is an assistant professor of medicine at Johns Hopkins School of Medicine and chief of the allergy section at the Inova Fairfax Hospital. He is the author of over 50 publications and holds 3 patents on medical devices. Attendees who require a passcode, the word for today is illness. During the Q&A session, we will ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will be sending out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list to the left of your screen. Thank you all for attending today, and Dr. Rosenthal, the presentation is now turned over to you.
Okay, well, thank you very much. It's nice to be here and address this lovely audience. As far as my own background is concerned, you know that I'm not an attorney. I'm a practicing physician who has evaluated and cared for hundreds of patients who've been exposed to mold. Besides myself, I would rely on people such as mycologists, epidemiologists, toxicologists, environmental engineers, all of whom have produced materials that I rely upon. But I'm not an attorney. I've never played one on TV. But what I have tried to do is to understand the law in an effort to better bridge the disciplines of medicine and law and better understand the differences between how evidence is treated in a scientific setting as opposed to a judicial setting. So I'll share some of my understanding of that with you. I'll try to use the judicial process to better frame my suggestions as to how an expert witness in mold litigation might be of more assistance to counsel. I very much welcome your suggestions, your criticisms, and your feedback, so here goes. Well, got to change the slide. Not doing. Trying to change the slide. Okay, now, so let's first spend a few slides on mold. What is mold? Molds are microscopic fungi made of filaments from which spores are released. There are tens of thousands of varieties of mold. The spores settle on organic matter and they grow into new mold clusters. They're found indoors and out, and most importantly, they favor damp environments, and you can read the damp environments here. They don't grow on a dry surface. Let's talk about mold spores occur naturally indoors and out. They enter the domicile through doors, windows, HVAC, materials, humans, animals, and they need a wet indoor surface in order to support their growth. Let's talk about the established clinical effects of mold. Molds cause allergy, infection, and toxic effects. As an allergist, we generally see people who are allergic to mold. They have allergic rhinitis, asthma, or hay fever. Very unusually, they might have hypersensitivity pneumonitis with something called allergic bronchopulmonary aspergillosis. The latter is the effects of mold both growing in the body and causing an allergic reaction. Now, these effects only occur in allergic people. In a non-hospital setting, we see very little in the way of mold infection, and for the purposes of litigation, most people are concerned with the toxic effects of mold. Now, all molds can produce mycotoxins, but only under specific circumstances, of moisture, temperature, and nutrition. This is important. The presence of mold does not necessarily mean that mycotoxins are present. So what are mycotoxins? Toxigenic species such as aspergillus, penicillium, and stachybotrys, may or may not necessarily produce toxins depending on temperature, water, and nutrients. The identification of a mold in a home does not necessarily establish the presence of mycotoxin, and even if they are present, they're actually not likely to be dispensed in a significant dose or accessible to people. Now, mycotoxin-producing molds may be present in inaccessible areas, such as behind walls, but if they have no opportunity to inoculate the indoor ambient air, then they can't be blamed for any kind of causation. So only supporting data documenting their presence in ambient air really establishes the presence of airborne mycotoxins, and we'll talk more about this later. So let's look at what we do know in terms of a reliable source. This is from the Institute of Medicine. The Institute of Medicine is I want you to know, the Institute of Medicine is part of the National Academy of Medicine. It's now known as the National Academy of Medicine, and it provides national advice on issues relating to biomedical science, medicine, and health. It serves as an advisor to the nation to improve health and it provides unbiased, evidence-based, authoritative information and advice concerning health and science policy to policymakers, professionals, leaders in every sector, and the public at large. The Institute of Medicine is a very reliable source. They've studied this in great detail, and they find that there is not sufficient evidence of a causal relationship between the presence of mold and any symptoms. There is sufficient evidence of an association between the presence of mold and certain respiratory tract symptoms. So what's the difference between a causal relationship and an association? It's basically a statistical element there, but I would tell you that, for example, as far as association is concerned, a good example that I like to use is that hospital beds can be associated with death in the hospital, but there's no causal relationship. So this is basically a statistical relationship that's based on evidence-based medicine, and at this time there may be an association only really between mold and the upper respiratory tract symptoms of cough, wheezing, and asthma, and sensitized asthmatics. And we can prove that somebody is sensitized with either blood test or skin test, and that's basically it. Now, there's inadequate or insufficient evidence whether an association exists between the presence of mold and a whole litany of complaints that we very often see in litigation. And you can read this litany here for yourself. You have this slide, but it includes fatigue, neuropsychiatric symptoms, cancer, GI symptoms, and so on and so forth. And there really isn't any evidence of even an association between the presence of mold or mycotoxins and these elements over here. So how would you choose, these are some of my thoughts in terms of how you might want to choose an expert witness to confront some of the claims that are made regarding mold exposure. First of all, I think you would want somebody who's board certified. Board certified by the American Board of Medical Specialties. Board certified by the American Board of Medical Specialties means that this person has got a significant amount of training and has passed proper examinations in order to achieve expertise in a medical specialty or subspecialty. And the standards are profession-driven, and there's a great deal of requirements. You'll find that people are board certified in boards that are boards of convenience. Very often they're not certified by the American Board of Medical Specialties, and I think you need to take a very good look at that. Healthcare purchasers, for example, quality organizations always look to the American Board of Medical Specialties certification to help them identify excellence and commitment and continuous performance assessment and improvement. That's very important. And the next slide shows some of the ABMS specialties that you should be looking at. So I, for example, am board certified by the American Board of Allergy and Immunology, which is a subboard of the American Board of Internal Medicine. And these are some of the boards that you will be coming in contact with. And they're both boards and subboards. So, for example, internal medicine has GI, infectious disease, pulmonary disease, rheumatology, and others. But this is a very, very important credential to look for both in your expert witness and to look at in the expert witness that's proffered by the opposition. So I have some slides that are concerned with what I think the experts should be doing in the courtroom. I think the litigator should endeavor to present objective and well-published experts who have knowledge, experience, training, and the skill to assist them. And that's right out of Federal Rule of Evidence 702. So we need somebody with the experience, education, training, and skill to assist the jury in understanding complex medical issues. But there's more to it that you're not going to find in the Federal Rules of Evidence. And that is that they have to have a certain sense of genuineness, clarity, humility, and be objective without bias. Hubris, arrogance, pomposity are counterproductive. Just now, here's another thing that you're not going to find in the Federal Rules of Evidence, and that is that testifying experts may be accused of bias and the influence of money, regardless of their credentials. They have to be prepared for that. I think if I were asked how much money I was getting for my testimony, which is not an uncommon question, I would answer by saying that I'm not getting paid anything for my testimony. I'm getting paid for my time. So what should be the basis of the medical testimony provided by the medical expert? The foundation should be built upon a critical review of pertinent scientific and medical facts, relevant literature, or other relevant data. And I think the expert should be prepared to state whether his opinion is based on personal experience, specific reference to peer-reviewed literature, and generally accepted professional opinion in the relevant scientific field. I think it's important. The scientific field has to be relevant. And once again, Federal Rule of Evidence 703 gives you the basis of opinion. But your expert witness also should be looking at the opinion of the opposition and make some determination and advise you as to whether or not that opinion is also based on the facts and the data that are reasonably relied upon by an expert. What is the expert for the opposition, for the other party? What are they relying upon? I think that's something that your expert witness ought to be able to share with you. So, the expert in the courtroom should be able to speak to the validity and reliability of his or her opinion. They should be able to predict conflict with opposing opinion, and they should be prepared to offer some reconciliation to support their own opinion. They have to be very careful not to abandon objectivity and become an advocate for the client. I think there's a tendency to do that. I've seen that on myself. You have to make sure that you're objective and that the expert is advocating for his opinion and not advocating for the client. The expert should be thorough, fair, impartial, and free of personal interest with no exclusions of relevant information. If there's information that actually is of interest or accrues to the benefit of the opposite party, that should be revealed, and possibly one could immunize that information if it's against the interests of the party that the expert is helping to represent by disclosing that up front and essentially immunizing against it. And finally, expert costs should really reflect the work scope. This is part of the ethics of an expert witness. This is coming from the American Medical Association and other organizations that do have statements about ethics of doctors who are testifying. Expert costs should reflect the work scope, and good documentation is advisable. Fees should be reasonable and commensurate with time. Okay, well, let's say I'm retained as an expert. What will I ask for? I'm going to ask for a number of documents that I think will help me to help the lawyer that hired me. And in particular, and you can read this over here, and you'll have this in your slide set. But in particular, I'd like to look at the complaint. What is the litigant complaining about? What are they claiming? In particular, I'd like to look at the deposition of the plaintiff, and if one exists, and I want to see who I'm up against. Who is the expert for the other side? I'd like to see their curriculum vitae. I'd like to see their expert witness designation. And if they were deposed, I certainly want to see their deposition. If they weren't deposed, then I might be able to offer some suggestions to the attorney who hired me in terms of deposing the plaintiff's medical expert. And of course, if there are any reports or affidavits from that medical expert, I want to see those. And naturally, I want to see the plaintiff's medical records, laboratory reports, consultations, etc. Another element that I think is important for me to know about is what's the foundational literature proffered by the plaintiff's medical expert? How reliable is that literature? And we'll get into reliability of literature as an issue also. Let's talk about medical causation, and particularly with analysis of mold illness. And here's a trilogy that I got from the literature. I got this from some literature that was written by an article, really. It was written by an attorney, toxicologist, and a physician. And it's a trilogy of does, can, did. Does a plaintiff suffer from mold and mycotoxin-related ailment in the first place? Can the alleged causal agent, which is the mold or the toxic agents, can they cause the ailment caused by the plaintiff? And finally, did the mold mycotoxins cause these ailments in the individual plaintiff in the first place? So that's our trilogy, and we'll come back to this. Does, can, did, in terms of medical causation. First of all, does the plaintiff have the illness? Second of all, can the illness really be caused by mold or mold toxins? And lastly, did in fact the mold toxins cause those ailments in the plaintiff? So let's go with does. The expert witness can help to develop a logical argument supporting one or more conclusions about the case. For example, does the patient have illness attributable to mold? Now, claims of illness attributed by the plaintiff to mold exposure are not credible, actually, because mold exposure in a damp indoor environment is not recognized by the medical community to have causal relationship to the specific ailments enumerated in this complaint. Now, this is an example, of course, but very often that's going to be the case. So even from the does step, I think the expert witness can help you determine whether or not the patient has the illness in the first place. Can the household mold exposure be reasonably accountable for any toxic effects of airborne mycotoxin? Well, mold exposure from a damp indoor environment is not considered after comprehensive inquiry by the scientific community, such as the Institute of Medicine, the American College of Occupational and Environmental Medicine, the American Academy of Allergy, Asthma, and Immunology. It's not considered to be capable of generating sufficient airborne mycotoxin to affect the health of individuals in a non-industrial, non-agricultural environment. So if the person is not filling silos, for example, it's very unlikely, if not impossible, really, for them to have a sufficient airborne mycotoxin exposure to affect their health in the first place. So that goes to the can part of the trilogy. And finally, did. Specific causation. The last slide is general causation. I should go back to that over here. Can household mold exposure be reasonable accountable is general causation. And then we've got specific causation. Did the plaintiff suffer from illness due to mycotoxin exposure? So if there were no evidence of mycotoxins detected in the plaintiff's ambient air, if none of that was proffered, nor was there any direct evidence of mycotoxin exposure by the plaintiff, then their case may be very weak. Accordingly, if there's no proof that the plaintiff suffered from a mold-related illness due to inhalation of airborne mycotoxin, that essentially goes to the did component of a trilogy or specific causation, which your expert has to help you with. Okay, now time for questions.
Could all the attendees please type the passcode into the Q&A?
That's great. Okay, here we go. Does a mold affect children differently than adults? The answer is probably not. There's no reason to suspect that it would. The physiology of children is the same as the physiology of adults with respect to allergy and immunology. I'm going to read this aloud. An allergist, an immunologist, or a pulmonologist, or neurologist is the best option for a claimant with respiratory, allergic, and neurological conditions, which is, I would say, I'm partial to an allergist and immunologist, basically because the allergist and immunologist is going to go to the principles of causation. The pulmonologist and the neurologist are going to be more focused on the outcome of the illness, the nature of the illness and the outcome. But as far as causation is concerned, the allergist and the immunologist is much more concerned with the pathophysiology of the response to mold in the first place. What methodology should an expert in this field use in evaluating claims of medical issues arising from mold exposures? Well, I think we can go back to some of these slides over here, but I think the first methodology is to look at the does, can, did. What methodologies would you use to determine whether or not? Let me go back to that. Whether or not the claim is reasonable in the first place. In other words, does the plaintiff suffer from a mold-related ailment? The methodology is to really look at the ailment then and to determine what is the foundation, what are the facts and data in the scientific community that bear upon that to determine whether or not, can we post back, can we put that question I'm answering, can we put that back on the screen? At any rate, hold on a second. No. Okay, that's it. That's what we want. Okay, what method? We're talking about the methodology right now. What methodology should the expert use? First methodology is to consult the literature to determine whether or not the claim being made fits the mold of whether or not it's possible. Does it? Then, of course, can, as a general causation. And again, I think it's the same methodology, really, to look to the literature and expertise that's already out there to determine whether it can. And then, of course, did goes as specific causation. You would have to possibly examine the claimant, examine the claimant's medical records, examine the claims made by the expert witness of the claimant to determine whether or not there's causation. So I think as far as methodology, it's essentially a careful analysis of the trilogy of does, can, or did. Let's go to okay, here we go. In a toxic mold case, is it advisable to seek an IME to determine the legitimacy and the extent of symptoms and or confirm the diagnosis, or is a review of medical records, testimony, etc., more appropriate? I've done both. In one instance, an IME is just simply another opportunity for the claimant to retell their story and get their story into your medical record. On the other hand, if you don't do an IME, then the question is going to come up in court as to whether or not you actually examined the claimant, examined the plaintiff. In my experience, I'm probably happier doing the IME because it gives me a chance to directly ask some of the questions that were raised by the claimant's expert witness and the claims that are being submitted. So not to say that it's a deposition, but it gives me an opportunity to medically determine some of the facts that you would want to discover, that you'd want to establish in a discovery deposition. So by and large, I think the IME is very useful, especially if the doctor can specifically target some of the claims that are being made. What did I do here? 1 second. Okay, here we go. What medical test do you recommend to assist in investigating mold? Is that right? The medical test. Well, depends. Once again, it depends on the kind of claims that are being made. If the patient has pulmonary claims, then of course you want to do a pulmonary function test. If the patient has claims of allergy, I generally don't like to do a skin test, but I will do a blood test. You can do a blood test to determine how allergic that person is. Other medical tests are usually laboratory tests. There's a number of blood tests that one can do depending on the claims that are made. But by and large, medical testing is going to be, depending on the claim, a history, a physical, a blood test for allergy, a pulmonary function test, and laboratory tests. And based on that, the expert medical witness ought to really have a pretty good idea about what's going on. do toxicological test results on the injured plaintiff have to detect the same toxin which is found in the environment claimed to be contaminated with mold? Well, actually, there's very little or no toxicological tests available to determine whether or not the toxins that they are claiming they've been in contact with are actually to be found in the plaintiff. There are some urine tests. There are urine tests for some of these toxins, and that's about it, and they are really not very well established. So basically what you're stuck with is tests to determine damage. So let's say, for example, let's take allergy, something that's more conventional. If somebody was exposed to mold and they were claiming asthma, then the test that you would do would be a pulmonary function test to determine if they had asthma. So the tests that one would do on the plaintiff are by and large, we'll have to call it indirect evidence to determine whether or not there were effects from mold exposure that could reasonably be expected. I'll have to emphasize that. Could they reasonably be expected? Go on here. Is there any literature or article supporting the claim of toxic effects fatigue used by exposure to mold? The answer is categorically no. If you go back to my early slide, in terms of what the Institute of Medicine has determined, you're going to find that there's inadequate or insufficient evidence of even an association. Remember now, an association is a very weak link of causality. The highest element of causality, causation, would be causal relationship, and this is determined by a literature review to determine the strength of the literature that supports these things. So a causal relationship does not exist, nor does an association exist by which one could reasonably validate, reasonably assume, reasonably conclude that fatigue is caused by exposure to mold. Are allergy tests helpful in determining the legitimacy of the claimant's claims? It depends on what they claim. If they're claiming allergy, then the allergy tests are, of course, very, very helpful because that's an objective, well-established, well-documented kind of a test that's well-established and accepted by the medical community. So allergy tests may be very useful in determining the legitimacy of the claimant's claims if they are claiming that they are allergic to the mold. There's two kinds of allergy tests. There's a skin test and there's a blood test. The blood test and the skin test are basically telling the same thing. They correlate with each other very, very well. And I personally prefer doing the blood test because I have some hesitation about sticking needles into a claimant. But if we send them to the lab, we can get a very reliable blood test to determine whether or not they're allergic in the first place, and that bears very fundamentally, may bear very fundamentally on a claim of allergy. I think we got this one over here.
Okay, those are all the questions that we have for now, so please continue with the presentation.
Okay, thank you. So we'll go on now. Okay, what's the role of now? I'm going to get into what I think maybe the role of the expert witness. I think the expert witness can also help to analyze and determine weaknesses in the plaintiff's expert witness designation. So I want to see the plaintiff's expert witness designation. Very often that designation incidentally has been written not by the plaintiff's expert witness, but by the plaintiff's counsel. It may never have even been seen by the plaintiff's expert witness, and I want to see what the expert witness of the plaintiff is going to say. I want to evaluate the plaintiff's expert theory for foundational weakness. We talked a little bit about foundation. Once again, if we look at Federal Rule of Evidence 703, we're going to see that they should be looking at facts or data that's of the type reasonably relied upon by experts in a particular field. So I want to know, what's the foundation? Is that foundation going to be unsupported opinion, or is it going to rest on peer-reviewed literature? I'm going to offer suggestions for deposition and cross-examination of the plaintiff's expert. I'm going to evaluate the literature provided to bolster the plaintiff's claims. What kind of literature is it? Is it anecdotal literature? Is it case reports? Or is it good peer-reviewed studies that are randomized and doubly blinded. And where did that literature appear? Did that literature appear in scientific journals of merit? And there's even a way of determining the impact of that literature in terms of doing a citation index. In other words, if that plaintiff provided literature, we want to know what's the impact of that literature in the scientific community. And you can ask the medical librarian to do a citation index for that literature and determine how important that literature was, what the impact did that literature actually make in the medical community. And finally, I want to assemble evidence-based medicine resources to bolster my opinion. I want to see what kind of resources the opposing expert used to bolster his or her opinion. Okay, now let's take a look at the expert's method, the plaintiff's expert's method. We want to look at that. Has there been repetition and verification of the disease mechanism by others published in peer-reviewed literature? Or is that is the plaintiff's expert's method only known to the plaintiff's expert? We want to know how accepted, how widespread the plaintiff's expert's methods are. And then finally, what's the supporting literature? Is there evidence-based literature to support the plaintiff's method? Some of these methodologies that come into court are actually what we have to call junk science. They're not accepted by the medical community. They don't meet the so-called Fry criteria, and they won't meet the Duber criteria either. So are the plaintiff's diagnoses generally accepted? Does it appear in the ICD-10? What's the ICD-10? That's the International Classification of Disease, the 10th edition. It's put out by the World Health Organization. It recently came into widespread use in October of this past year, and every doctor in the United States has to use it. So you need to know whether or not the diagnosis proffered by the expert witness for the plaintiff actually appears in the ICD-10. Is it an established diagnosis that will appear in the International Classification of Disease? So I won't read this all to you. You can read this, but I just want to point out that the ICD-10 is required by anybody covered by HIPAA. It includes doctors, hospitals, health insurance companies. The entire world relies on the codes for diagnosing these patients and billing for services. And a lot of the illnesses that are claimed for mold illness don't appear in the ICD-10. That would include chronic biotoxin-associated illness, sick building syndrome, chronic inflammatory disease, for example. They are nowhere to be found in the International Classification of Disease. They are by and large made-up illnesses with a number of acolytes following the guru who has made these up, but essentially they are not recognized. I think that's important to know. Let's talk more about the reliability of the plaintiff's expert method. Are his diagnostic terminology, diagnostic approach, workup, pathology mechanisms, are they generally accepted? Are they generally accepted in the relevant side of the medical community? And I'm going to underline relevant. And that's basically the Fry criteria of reliability. I know you all know about the Fry decision. I'm going to mention it a little bit later, but these are the criteria of reliability. And or do they meet the additional but more flexible Duber criteria? The Duber criteria are going to include the approval of peer review, known error rate, and testing. The Duber criteria used in federal court more are going to be a little bit more flexible, but you need to know, does the expert's method meet those criteria? Do they reflect the established and generally accepted concepts of mechanisms, evaluations, and treatment of the illness in question, or are they self-generated? That's an important distinction. I think your expert witness can help you with that. Let's talk about the scientific method, because that's going to come into play. What is the scientific method? First, observations of some phenomena are made. Then, possible explanations or theories are proposed for observation. Then, a hypothesis or a conclusion is logically derived from the theories. Then, we have studies. These are empirical or observational tests are designed to test a hypothesis. Then the theory is either abandoned, revised, or confirmed, and then further testing leads to further evaluation or reevaluation. And I will point out that further testing always leads to, further testing is going to lead to confirmation. So we have the scientific method over here. You should know this, and then you should know that further testing always leads to confirmation. It's important to have this confirmation as a means by which to further validate the conclusions that are derived from the observations that are being investigated. So let's talk about Fry. I know you all know about Fry, and I know that I'm out of my comfort zone discussing this, but it's something that I think your expert witness should know about. Your expert witness should know whether or not the methodology of the expert for the plaintiff enjoys the general acceptance in the particular field in which it belongs. And that should be easy for your expert, since you've got an expert who's board certified in the relevant field. That should be pretty easy for your expert to determine. And then, of course, Dalbert, that you all know about. Dalbert provides some more flexible criteria for screening in or screening out scientific evidence from the courtroom. But basically, it's going to be a filter. It's going to be a filter for junk science, we hope, and it includes, besides general acceptance, it's going to include the more flexible criteria, I believe, of testing. Was testing done? Has the methodology been subject to peer review and publication in journals that are reliable? What's the known potential error rate? Are there standards and controls concerning the operation or the methodology? And then finally, back to Fry over here, the degree to which the theory and the technique is generally accepted by the relevant scientific community. So I was told that Byrne is essentially Fry on steroids. But I think even though you may be operating in a state that uses the Fry principle, your expert witness should be familiar with these principles of Dalbert and be able to tell you whether or not the methodology of the opposing expert meets these criteria. Okay, well, here's the Federal Rule of Evidence 702 that I pulled out. We've talked about this before. So the witness is somebody who's going to be qualified in terms of his knowledge, skill, experience, and training. Okay, and he has to also use a sufficient testimony based. He has to give testimony based on sufficient facts and data. The testimony should be the product of reliable principles and methods, and he should have reliably applied the principles and methods to the case. But I'm going to add another element, another component to FRE 702, and I'm going to say that your expert should be able to make the same determination of the testimony proffered by the expert witness from the other side. He wants to say whether or not the testimony proffered by the other side meets these principles, and we also want to say whether or not the facts or data relied upon by your expert and the other expert are the type reasonably relied upon by experts in the particular fields in forming opinions, or are they, on the other hand, unsupported opinion, case reports, and anecdotal. Okay, so what are some of the claims as a consequence of mold exposure? A lot of these claims are essentially what we have to call junk science. Sick-Pelton syndrome, fibromyalgia, not all of them, chronic fatigue syndrome, reactive airway dysfunction, toxic encephalopathy, multiple chemical sensitivity, chronic inflammatory response syndrome, and then multiple and diverse somatic and psychological complaints that may not be validated, that you may not even find in the International Classification of Disease, and which may lack any kind of reasonable, reliable, or convincing or persuasive support from the medical literature. Let's talk about mold now. Now that we have laid down these principles, let's talk about the purported sequence of events in most mold litigation. The claim often is this. The following bullet points really describe the claims that are very often made. Mold was growing in the plaintiff's living space. Therefore, the mold produced the mycotoxins. The mycotoxins traveled through the air. The mycotoxins were respired by the plaintiff. The mycotoxins then caused the symptoms claimed by the plaintiff. they came to reside in the gastrointestinal tract, and they linger indefinitely in the gastrointestinal tract. This indefinite linger of the mycotoxin in the gastrointestinal tract are going to be responsible for changing the life of the claimant and essentially giving them illness really for the rest of their life, which has to be accounted for. And despite their residence in the GI tract, they cause systemic symptoms, which would require residence in the bloodstream, which doesn't make a whole lot of sense, and they're susceptible to complexing with cholestyramine and elimination. Cholestyramine is a medication which is used to complex cholesterol and bring down serum cholesterol. It's never been studied or approved for this purpose at all. But these are this is generally the litany of the claims. This is the disease pathology, which is very often claimed in mold litigation cases. Most of it are completely unsupported. So here are the questions to ask of those claims. And now this is going to go back to the principles that I laid forth earlier. Is a mechanism of illness and treatment biologically plausible? Well, most of what I just showed you is not biologically plausible. What are the possibilities given the established and well-understood biology of mold? Well, well-understood and established biology of mold makes the foregoing claims essentially not possible. And is it possible, focusing down even more, is it possible within the established framework of physiology and pathology? And the answer is really probably not. So what about this paradigm of mold illness? Is it biologically plausible? We're still working on that. Well, it requires the presence of mold, airborne toxin exposure, and the plaintiff and residual long-lasting resident toxins in the patient's GI symptom from toxins, and treatment with cholestyramine and fecal elimination. Actually, there's no reason to believe that that's possible, mostly because the half-life of mold toxins is only really on the order of hours. So cholestyramine, for example, which is used to get rid of the mold, supposedly, has never been studied for this purpose, and it's not FDA approved for this purpose. Okay, so this theory does not stand up to the type of inspection that I have outlined before. Well, I'm going to let you read this on your own, but basically we're going to have to confront, your expert should confront the plaintiff's expert's theory. Okay, is a mold survey proffered by the plaintiff reliable? Were spore levels similar to those seen in other similar domiciles? Were the mold genera commonly seen with water damage? What areas were cultured for mold? And this is the nitty-gritty, basically, of doing a mold analysis. You really need to focus down on this and determine, was there mold? What kind of mold was it? And ultimately, was there any mold toxins identified? And the last point I'm going to emphasize: how did the mold levels in the plaintiff's home compare to out-of-door spore counts? And spore counts in areas in the home that had no mold visible. Most of the time, a lot of the time, you're going to find that spore counts in the patient's home were no different than spore counts out of doors, in the ambient air out of doors, which means that the house the domicile didn't even really concentrate the mold in the first place. The plaintiff may well have been at no more risk inside the mold-infested domicile than he would have been in the front yard. And then finally, and this is important, this will be important in a decision that I'll share with you, has the exposure of the plaintiff to mold toxins been verified in any way? Was there any identification of the toxins in the respirable air to which the plaintiff was exposed? That's general causation. And was any body fluid or part of the plaintiff examined and analyzed for the presence of toxins? And that goes to specific causation. Very often you'll find the answer to both of them is going to be no, but you're going to have to establish that in court. And then finally, could the plaintiff's reported symptoms be otherwise explained? What about the differential diagnosis? It's very hard to prove a negative. That a plaintiff doesn't have this and so. But it may be more useful to replace a negative with a positive, which is to say that other illnesses, other elements, other pathology could easily account for the symptoms that are being claimed by the plaintiffs. Now, in that regard, I would caution that I think your expert witness has to be very careful to stay within their expert witness designation. I think your expert witness should write or help to write their own designation and stick to it. Your expert witness shouldn't get dragged into or I should say, shouldn't get dragged outside of the rather narrow area of their designation, because if they start to explain away symptoms based on areas in which they have no expertise, I think they could get trapped. It's going to be up to you, the attorney, to establish otherwise alternative diagnoses. I think that's a little bit of a trap that's waiting for the expert witness, because they're anxious to play the game we learned in medical school, which is, you name it, we explain it. So how else can we confront the plaintiff's expert theories? Well, what was the evidence of the presence of molds in the first place? Molds may or may not produce mycotoxins. Even a mold which is considered to be toxic, like Stachybotrys, may not necessarily produce mycotoxins. It's going to depend on humidity, temperature, the substrate on which it's growing, competing molds, so on and so forth. Did ambient air demonstrate any evidence of mycotoxin on mold spores or mold particles? Once again, the presence of mold doesn't necessarily mean that there was mycotoxin in the air. Were there mycotoxin on particles in the respirable range? That's 1 to 3 microns, documented in the plaintiff's domicile. Or is the plaintiff's attorney just simply assuming they were there because somebody saw mold? Usually the presence of mold is not in dispute. What's in dispute is whether or not the mold produced mycotoxins, and the mycotoxins were in the air, and the plaintiff actually respired those mycotoxins. And finally, here's a technical question. How did the mycotoxins get from the lungs to the GI tract? I've never seen this successfully answered. The mycotoxins are respired, they're breathed in, supposedly, because they're in the air. So what are they doing in the GI tract? How did they get there? You couldn't possibly swallow enough of it. So is there any evidence that mold spores that are inhaled can also be swallowed, or is that conjecture? In other words, it doesn't really fit together biologically. It goes to the can component of our trilogy. Now, very often these witnesses for the plaintiff will provide all kinds of laboratory tests. What about those laboratory tests? We have to look at them and say, okay, have the special lab tests used by the plaintiff's expert been cleared or approved by the FDA? And can the laboratory pathologist state the purpose or rationale for the test? Most of the time, those tests are investigational. There's no database to back them up. They're not approved by the FDA for that particular purpose, and the laboratory pathologist would be at a loss to explain them in terms of mold-related illness. So we would ask the pathologist to state the clinical meaning on the elevations of these tests, and then again, drilling down on that, in what way have these tests been authenticated in a controlled study for the diagnostic activity at issue? Those are going to be questions for the plaintiff's expert. And then finally, we talk about sensitivity and specificity. It's a little hard to get your arms wrapped around sensitivity and specificity, but the best way to look at it is this. The sensitivity of a test is the rate of true positives, and the specificity of a test is the rate of true negatives. In other words, this goes to the accuracy of those tests. I think you have to get your arms around this ultimately and make a determination about the accuracy of the tests that are used as a means by which to support the claim of mold sensitivity and determine the known sensitivity and specificity of those tests. Right? To those tests, especially the specificity, because we want to know the rate of true negatives. In other words, if that test is positive, is it truly positive, or is it one that otherwise would have been negative? More challenges in plaintiff's expert theory. This is very important. Mycotoxins have a half-life of only several hours to days at most. So a good example of a mycotoxin that we all know is penicillin. Penicillin is a mycotoxin. Penicillin has to be given 4 times a day unless it's a depot shot, okay? So how do we account for mycotoxins lingering for very extended periods after putative exposure? Mycotoxins don't last that long. And furthermore, if they reside in the GI tract, how do they give systemic effects? And conversely, if they circulate indefinitely in the bloodstream, why are they susceptible to being bound by cholestyramine that's given, as a medication in the GI tract? In other words, it doesn't fall together in terms of the known pharmacology of mycotoxins and the known pharmacology of cholestyramine. So finally, have any measurements or determinations of the mycotoxins been made in the blood of the GI tract on the plaintiff? Or does the plaintiff just simply assume that they're there because they have symptoms that they attribute to it and because mold was noticed in the domicile? And let's talk about cholestyramine, which is popularly used. Cholestyramine is approved only to complex and eliminate cholesterol. How do you know it works on mycotoxins? And what's the pharmacologic demonstration of this? No matter how you slice it, no matter how you dice it, the pathophysiology proffered in these cases often by the plaintiff's expert witness just simply doesn't hang together. It doesn't make any sense. And one of the biggest nails in that coffin is the mycotoxins have a very short half-life in the first place. Within a day or two, they're gone, and if they were swallowed, and if they did get in the GI tract, they'd be digested even more quickly yet. So these are some components that have to be accounted for in terms of evaluating what is really junk science. So once again, diagnostic reliability of the plaintiff's method. Okay, what's the sensitivity of the method? We talked about sensitivity and specificity. I'm going to let you read this. What's the predictive value of the method in terms of sensitivity and specificity? I'll let you read that. It's just questions that you have to ask. And then basically, is there a recommendation from the U.S. Preventative Services Task Force? How do they grade those tests for diagnosis and treatment of disease, such as chronic inflammatory response syndrome or signaling syndrome? If you look into it, you're going to find that these tests very often are not considered to be reliable. They're not accepted in the conventional medical literature. Now, I'm going to wind up with an observation of my own, which I think is of interest in terms of working with doctors. First of all, I think that doctors spend a lot of their time making molehills out of mountains. They tend to paper over inconsistencies and gaps in knowledge and information with assumptions. We do that all the time. Doctors generally don't basically thrive on inconsistencies. Okay, they basically paper over the inconsistencies with assumptions, and they go with that, and they're usually correct. Now, because doctors' opinions are not generally subject to challenge, and they're usually not offered in an adversarial setting, doctors don't prune the decision tree so judicially, but they can usually get away with just so much ipsedixit. Ipsedixit is basically an unsupported, essentially an unsupported assumption. Hold on a second now. So, ipsedixit is an unsupported dogmatic statement that rests solely on the authority of the individual who makes it. And so I would say that in a courtroom setting, ipsedixit is not going to be ipsedoodle. So let's talk about ipsedixit. We want to know to what extent are the plaintiff's expert statements conclusory ipsedixit statements based solely upon his authority and credentials. It's going to be an opinion that's basically unsupported. Do they rise above subjective belief or unsupported speculation? And has the plaintiff's expert made sweeping assertions without providing supportive data? I think that's an issue. I think those are some questions that your expert witness should ask you about, should counsel you about. Finally, differential diagnosis versus causal assessment. Some of the courts accept differential diagnosis instead of causal assessment. Let's talk about that. Differential diagnosis is the determination of which of two or more diseases with similar symptoms is responsible for the clinical illness. Differential diagnosis about what the condition actually is in order to determine treatment. Differential diagnosis, or the determination of a diagnosis, does not give you causation. In other words, you cannot necessarily back causation out of a diagnosis. That's very important. Causal assessment is about how the condition came about in order to determine responsibility or liability. So once again, differential diagnosis, or a diagnosis that's reached by differentiating it from other possible diagnoses, does not fulfill the requirements of causation. Causation is yet another issue entirely, and that goes back to specific and to general and specific causation. Finally, I'm going to refer you to Chesson. I won't go over this in great detail, but you should all be familiar with the Chesson determination, and you'll have this. And essentially, what the Chesson Just in case, this was a typical case of what we'll call junk science trying to get into the courtroom. It was a mold case, and the court determined that the methodology was flawed. It was not generally accepted because it failed to account for levels of mold exposure. Actually, it didn't even account for levels of mold toxin exposure, let alone mold exposure. Okay, so that goes back to the did component, which is specific causation. And then our last sentence over here, the court found that based on the examination of relevant scientific journal articles, that the scientific community remained uncertain, and that's a kind word, I would say unconvinced, as to the plaintiff's experts' techniques and conclusions. And that goes back to the can component of a can, cause, and did. And that goes back to basically the general causation question. So I think that's basically what my proposals would be for you in terms of choosing an expert witness, in terms of what to ask of the expert witness. You'll have these slides to study. And of course, if any one of you want to get a hold of me to ask more specific questions, we could do so. And we have time now for some questions at this point.
Could all the attendees please type the passcode into the Q&A?
I'll read these over here. To what extent, if any, does the medical community view the effect of mycotoxin exposure have on neurological injuries? And the answer would be briefly none. There is no evidence. There's no evidence of causation, certainly, and there isn't even any evidence of association. This was looked at specifically by the Institute of Medicine, and if you read the Institute of Medicine issue on this, you're going to find that they specifically mention neurological and neuropsychiatric symptoms as even lacking in an association between the presence of mold and those symptoms. Can mycotoxin exposure trigger nascent genetic predisposition to autoimmune diseases? If so, what level of exposure would trigger it? To my knowledge, there's absolutely no valid scientific data to suggest that at all. I know that that's a popular theory that's held in the mold toxin community, and I know that they have tests that they claim are relevant to that. But I think if you look at the literature, that there's no reliable literature. There are no reliable factor data that bear upon that. That would essentially make the determination that mycotoxin exposure triggers nascent genetic predisposition. Or if there is literature, I certainly want to see it and inspect it and subject it really to the Dauber criteria. Are you aware of any regulations that mold is prohibited in classrooms for kids? I know that schools are concerned with this. I know that schools have done, particularly in Connecticut, for example, a lot of remediation. But as far as prohibition is concerned, I don't think there's any prohibition. There's no prohibition for mold. There's no prohibition for pet dander. There's no prohibition for pollen. There's no prohibition for kids coming to school that are sick that should have stayed home. Another one here. I think we answered this one over here. Any others here? Do you think it would ever be possible to prove a mold-related case without an expert? Well, I think it's going to depend upon what the plaintiff has. If the plaintiff has an expert, I think, and I was an attorney conducting such a case, I would certainly want an expert. I think I would have to engage in the war of the experts. I guess it depends on how much the attorney knows. But once again, the expert is one, You know, the expert's the one who can give the opinion. The expert's one of the few people, if not the only person, who's entitled to an opinion in court. And I think you need that opinion. You need the expert who's got the knowledge, the skill, the experience, the training, and the education, who can give an opinion by which to influence the jury. Otherwise, I think it's going to be a lot more difficult to counter the opinion of the expert witness for the plaintiff. That's my expert opinion. If someone has lung cancer, can mold make it worse? Well, that's a loaded question, really. You know, if somebody has lung cancer, then any number of things can make the symptoms of their cancer worse by another mechanism entirely. So let's say, for example, somebody's allergic to mold and has asthma due to the mold. And that unfortunate person also has cancer, and they have respiratory distress because of the cancer. Well, their mold allergy could make the respiratory distress of the cancer worse, more complicated, because of the respiratory distress from the completely unrelated mold allergy. So I guess you can always think of some mechanism by which two unrelated things might act symbiotically, one to make the other worse, even though they are themselves completely unrelated. I think that would be my answer. It could make it worse, even though it's unrelated. Depending on the mechanisms. How long must one be exposed before symptoms develop? Well, we would have to talk about mold allergy in this particular case. And it depends on how sensitized the patient is, or the claimant is. Well, in my case, it would be a patient. If I had, worst case, if I had a patient who was already sensitized to mold, and they were in a moldy environment, they would have symptoms within hours. But that's one specific kind of a case. It would depend on the claims that are being made, and it would depend on the nature of the plaintiff. As that plaintiff, we'd have to show that that plaintiff was in fact allergic to mold, and we would have to have some subjective and objective measure of those symptoms. Symptoms are by their very nature subjective. Objective is going to be laboratory tests, pulmonary function tests, physical examination. But in the worst case scenario, one could have symptoms from mold exposure really immediately. It could be an immediate hypersensitivity in the case of real allergy.
Okay, that's all the time that we have for questions. We do have some additional questions that, if you don't mind, Dr. Rosenthal, we could email those over to you.
I'd be delighted. Well, I want to thank everybody for their attention, and I enjoyed doing it.
In addition to being your best source for testifying and consulting experts for the past 60 years, TASA also offers e-discovery and forensic solutions, free interactive webinars, cybersecurity services, day-in-the-life videos, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Dr. Rosenthal for his time and effort in creating this presentation. If you would like to speak with Dr. Rosenthal, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. This concludes our program for today.